Hi everyone, my name is Louis. So I can build up on Tan Sri's answer. My question is to Amza and perhaps to Mr. Stephen. You mentioned that there's about 150 people that were charged with Sosma till this date. Do you agree that some of them indeed are involved in terrorism? And if that's the case, does that justify that we do need Sosma to counter these terrorists? And if we do say that Sosma is unconstitutional and therefore we do away with Sosma, do we have currently existing laws enough to tackle these issues?
I just want to share our experience in dealing with POTA, because we've been on a POTA roadshow throughout the country, almost in every state. And when we looked back, and one of the major criticisms that we've had of POTA is unnecessary, because we do have sufficient counter-terrorism laws in Part 6 and 6A. The predicate offences are there. And one of the arguments that we have made against POTA is if you need predicate offences, that's fine. You may need to upgrade your offences to deal with the threat of terrorism. What you can't have is POTA, because it allows for detention without trial. And that's the same argument we would use again for procedural laws. If you're looking at predicate offences, those are found in the penal code, you may need procedural laws. You may need procedural laws that are perhaps not found today to deal with the special threat of terrorism. Whether it's in detection, investigation, surveillance, you may need that. But what's critical for the bar is this. At every stage of those laws, there must be safeguards. And that is, in terms of Sosma, that's one of our major criticisms of Sosma. The safeguards are absent. You cannot have decisions on questions of, for example, extension from the initial 24 hours to 28 hours being made by the executive, in a sense, it's the police. You can't have that. There must be judicial scrutiny. There must be an independent arbiter who looks at the facts and says, well, in this case, yes, in this case, no. And even within the 28 days, we agreed to, we looked at it and we said, all right, other jurisdictions have 28 days. Sunset clause, it should be reduced after 5 years, if not sooner. But really, even within the 28 days, our primary argument, I remember when we were looking at the proposed amendments to SOSMA, was that should be actually, in a way, treated in installments, truncated or punctuated, if you like. So within 14 days or so, the detention and detaining authorities, the police, must produce the person before a judicial arbiter, before a judge, and make out a case for a further extension. Now, that serves the purpose of judicial oversight. So the person who's investigating is really investigating. And he's showing that he has done so much and he needs more time to complete the investigation. We cannot have, as we have in many cases, where a person is detained and there's really no investigation until the 26th day. So what happens for the first 26 days? We can't have that. And whether or not there's record of what has been done, whether there is a diary that is kept by the police and it's produced in this punctuated 14 days to show, well, in the 14 days, this is what we have done. But unfortunately, we're dealing with terrorism. It's quite complex. There's a need for evidence from all over, just not within the jurisdiction. We need more time. And this is how we propose to use the extension we are seeking, which is the further 14 days. That is needed. That's the kind of safeguards you want. Then there is somebody else who's looking at the entire process and being satisfied that the process is not being abused, that the person who is under detention is not being victimized. And what is being done is a genuine investigation by the authorities to the best of their ability.
Dealing with various threats to the state, to the public, to the federation. So we have those substantive laws. So the question is whether or not the procedural laws, the evidentiary laws are sufficient in order to try them in the court of law. To answer that question, I'm on the view that we have our Criminal Procedure Code. We have our Evidence Act 1950, which governs matters pertaining to investigation, trial process, and then appeal process as well. So we have all those laws in existence. So if you ask me from my point of view, yes, we have adequate laws to deal with those kind of scenarios. But under Article 149, as I think both Tan Sri AG and myself had mentioned, the Federal Constitution allows the Parliament to legislate special laws in order to deal with special situation. And when that special situation deals with threats to the Federation, whereby certain fundamental rights can be suspended in order to deal with that, or to arrest with that particular danger or situation. So even without Sosma, those who have been arrested for security offences can be tried in the court of law. We have CPC, we have the Evidence Act. So there is nothing, so we cannot say that just because we do not have Sosma, therefore they will not be brought to justice. That's not the scenario. It's just that having these special laws means that the police may have additional powers. They may have a lengthy period of time in order to investigate because of the nature of the alleged offence against the suspects.
That although we can say that SOSMA and other preventive law are draconian, but somehow we can see that threat of terrorism is so imminent. But we'll see, like, based on the experience dealing with those people being arrested under SOSMA and been detained, like, within that 28 days because of the abuse of power by the police who investigated them and interrogate them for the cause of investigation. So all the confession made is not made voluntarily, which is really against the law. And like, for instance, there's one case that I've represented this couple, it's a husband and wife. They purchased a ticket to Istanbul together with other family members and nephew and nieces, including like small kids, for a holiday trip. But before they went to Istanbul, they met this some guys who talk about ISIS, about Syria, and because of that, the husband and wife and the rest of the group been arrested 2 days before departure. And during the 28 days, she was like heavily interrogated together with the husband and been threatened that if you not confess to those allegations, you will not allowed to see your kids, and then you will be like you won't be released. You'll be detained here forever. So my client confessed, and then both of them were brought back. The police so happy with the with the confession, and then they provide all the basic facilities to this to the couple, like toothbrush and soap, and allow them to to shower, and brought them home. So they are so happy to see the kids, but then the purpose of bringing back for the police to brought them to their home is just for the purpose of search. And then after the search has been done, the police brought back them to the detention, and then they were baffled and asked the police, "So you promised me that you will will be released. I already confessed to to your allegation." But then the police just laughed at them. And this is only one of the the cases. There's so many abuse of process has been done. Of course, we can say that we need different measure of safeguard for terrorism offences. But when it comes to abuse of process, so I can see that everybody have have a right of equality under the law. So as Mr. Amir said, we already have adequate law. We have CPC, so everybody should have a right for fair trial.